Welcome to Uncertain Things. Today I have the honor of having Alan Dershowitz join me to have a brief chat about his latest book, The Preventive State. So I'm going to jump right in because we are short in time. You wrote this book to propose the argument or start the conversation about the need to have a more serious jurisprudential discussion about preventive measures or a preventive jurisprudence, which calls for thinking how how should a state legally intervene in order to prevent future harm. Now, I want to start with just a general question. There are different theories of law. If Kant thought that law is about expressing a categorical expression of pure reason, the Talmud sees the law as the link between the divine and social order. But I think in American society, we see law as a very consequential force, which to me brings the question, isn't law already, if we're honest about, especially criminal law in the penal code, about harm prevention?
No, in an ultimate sense, all law has as its goal the future prevention of harm. But the criminal law for the last 2,000 years, even probably before that, reacted to crimes. It waited until the crime was committed, and then it punished people in an effort to deter them from future crimes, to be sure. But I think what we're seeing now, we anticipated it in the movie Minority Report. I was actually teaching about this 20 years before the movie The Minority Report. When I started doing my research on this in the middle 1960s, there were actually more people confined in prisons and mental hospitals on the basis of predictions of what they would do than there were people confined on the basis of proof of what they had done. We had hundreds of thousands of mentally ill people in mental hospitals, sexual psychopaths, people being held on bail, even though we thought they had committed crimes that hadn't been proved. The theory was that maybe they'll commit new crimes or maybe they'll flee. So we saw the beginnings of preventive interventions, but we're seeing it much, much more now because two things have occurred at the same time. Number one, the dangers are much greater. We used to have retail crime, one person killing another. Today we have, mass terrorism. We have shootings in schools. We have threats of even the potential of nuclear terrorism. And so the threats are much greater than they've ever been, but our ability to predict them is also much greater. We're not at Minority Report. We're not there yet. But with artificial intelligence, red flag laws, those kinds of things, we're moving in a much more preventive way. And we don't have a jurisprudence. We're just doing it ad hoc. We know that after a person has been charged with a crime, we say it's better for 10 guilty to go free than for one innocent to be wrongly confined. Is it better for 10 acts of terrorism to be allowed to be implemented rather than confining one potential terrorist improperly? We just don't know that jurisprudence yet. And that's why, after many years of teaching this and writing about it, finally at age 86, I decided to write what I think is my definitive book, my contribution to the literature of the law. It's the most important book I've ever written. The New York Times, of course, will not review it because I defended Donald Trump against it on constitutional impeachment. And so the New York Times has canceled me. I used to be the most frequent legal book reviewer, and I would say 20 of my books have been reviewed by the New York Times. And I was their most frequent op-ed writer from the legal point of view. But once I defended Trump, the Times cut me off completely. Harvard has cut me off. I was supposed to start this book off at the Harvard Club of New York, and they canceled it because they didn't like the fact that I was not necessarily on Harvard's side when it came to Trump versus Harvard.
Have you been able to get any kind of commentary from the legal world outside of the limitations of Harvard and the New York Times?
Well, the book has tremendous number of.
I've seen Justice Breyer as wrote the
Justice
introduction.
Breyer, the introduction. Larry Summers, the former president of Harvard, praised it. Erwin Chemerinsky, the dean of the Berkeley Law School, praised it. Steven Pinker praised it. It's gotten a lot of praise. Nadine Straussian, the former head of the ACLU, Harvey Silverglade, and many others. It's gotten very, very strong recognition from academics, but I've been canceled. I'm happy to have a chance to explain my thesis here because this involves and affects every American. Take, for example, the decision by President Trump, whether you agree with it or not, to destroy Iran's nuclear reactors, or to attempt to do it. That was clearly based on prevention. That's the preventive state. He thinks he was justified in doing this without congressional authorization on a preventive theory. Israel likewise thought they were entitled to bomb Iran's facilities preventively, not reactively, although obviously both countries had the right to react to previous attacks by Iran, but both justified it on preventive grounds. When we required people to wear masks and get inoculations during the COVID pandemic, we did it on preventive grounds. There are so many areas today where there's a potential for infringing on civil liberties based on claims of prevention. Whenever the government acts in controversial ways, they always say we do it preventively. You know, Japan claimed that its bombing of Pearl Harbor was preventive. Hitler claimed that his invasion of Poland was preventive. You know, the United States has claimed that some of its military actions have been preventive. So we have to explore very deeply when prevention is justified, what actions are justified in the name of prevention, and what the appropriate jurisprudential framework should be for evaluating these actions. And that's what I try very hard to do in the preventive state, including giving numbers. I actually create a jurisprudence for prevention the first time this has ever been done. You know, it's not the final word. I hope people will criticize it and come up with better suggestions, but it's the beginning of a dialogue.
So at stake, as you set up at the beginning of the book, is the problem between getting a false negative case where you did not prosecute a crime preemptively and the crime did take place, and if it's a large-scale terrorism or a pandemic that you failed to prevent, then the cost is massive. And on the other side is the false positive, punishing an innocent person for a crime he will not have committed.
That's right.
So first of all, is there no other issue at stake? Is there no potential abstract value of not punishing a person preemptively?
Sure. I mean, we basically say our jurisprudence is based on not punishing people preemptively, but we do it all the time. And if you ask 1,000 Americans, if you could have prevented 9/11 by locking up 10 potential terrorists, 7 of whom were innocent, I would say 99.9% of Americans would say, sure. The value of preventing 9/11, in which thousands of people were killed and injured, was greater than the possibility of some false positives. The worst example of a false negative, and I outline it in great detail in my book, was the failure of Great Britain and France to preemptively attack Nazi Germany in 1935. Even Goebbels said, we expect to be attacked. We're violating the Versailles Treaty. We're building up our army. And if France and Britain had attacked, probably 10,000 deaths would have resulted. Everybody would have been called warmongers, and maybe 60 million lives would have been saved, because Hitler would not have been able to bring about the Second World War with that enormous number of casualties. So that's probably the worst example in world history of a false negative. But had there been action, the people would regard it as a false positive. They would say, oh, Hitler was just a tin horn dictator. He never would have kept his promises. He wouldn't have done any of those things. Why'd you have to kill 10,000 people? And the same thing is true now with Iran. If Iran's nuclear weapons have been destroyed, and by the way, the Americans seemed, whatever they did, whether it was successful or not, there were no casualties. So they did it without casualties, much the way Israel destroyed Iraq's nuclear reactor and Syria's nuclear reactor without casualties. Sometimes you can get a free lunch, but the failure to do that, who knows what it would have happened if Iraq had nuclear weapons, and of course we now know they didn't, but if they had a nuclear weapon and the United States went in, it could have caused enormous numbers of casualties. So the problem is mostly we do this based on our inability to accurately predict what will happen either on the false negative side or the false positive side. So we're always dealing with probabilities, and that's why it's so important to have a jurisprudence of probabilities, which is very difficult.
With regard to Iran, we are even seeing the difficulty in thinking retroactively about events prevented in the conversation about why does Iran seem to have been for 30 years on the cusp of nuclear enrichment? And the answer is, at least in part, because Israel has been actively launching operations, both covert and open, to sabotage Iran consistently. And whenever such an event comes to the news, it is often criticized as escalatory by critics of Israel,
Sure.
while now, when the same critics are trying to blame Israel for launching the attack, they say, well, look, Iran has seemed to have been on the cusp of the threshold for 30 years and it hasn't really crossed it. So clearly you're lying. It's very easy to manipulate the prevention of harms that did not come to pass, but it's also impossible to evaluate it with certainty from the people who want to defend this
And
argument.
that's why it's always a question of probabilities. Let's assume Israel says there's a 10% chance, just a 10% chance, that Iran is on the verge of developing a nuclear weapon, that they're up to 60% enrichment, they can get up to 90% enrichment very quickly. Let's assume they're only 10% right and 90% wrong. The potential of a false negative here is so great that maybe a jurisprudence would say you can act on the basis of 10%. On the other hand, if it's only 10% of a non-nuclear attack, of a conventional attack, maybe it has to be 50 or 60%. So we need to create a jurisprudence to tell us when it's appropriate to act on probabilities. And, the law is based on probabilities. We have issues like probable cause. What does that mean? That's a probability. Proof beyond a reasonable doubt. That's a probability. Proof by a preponderance. Those are all probabilistic concerns, and we have jurisprudence about that. But we don't have a jurisprudence that tells us when a country can act preventively on the basis of a low probability of a very terrible, terrible event, or a high probability of a low cost event. These are all factors that I write about. And in my jurisprudence, I try to create numbers of when it's going to be possible. I assign numbers to the seriousness of the event. I assign numbers to the probabilistic and likelihood. These numbers aren't written in stone, but they're designed to start a debate about when we're going to make errors, and we're always going to make errors. Is it better to err on one side than the other? When it comes to criminal convictions, we've made that decision. We say it's better to make the mistake of freeing 10 guilty people than to make the mistake of confining one innocent person. But we haven't created a similar jurisprudence for prevention.
There's another issue, though, beyond the measuring of probabilities. And I think your method focuses on, and I want to give you a chance to explore it a bit further, but your method depends on assigning values to probabilities and to potential harm and weighing them against each other. But there's also the more difficult to quantify layer of the social presentation of the law, or the sense of morality that a society takes from the ideals that the law represents. And there is a performative aspect to the legal system as well. Like, a punishment does not only serve to retroactively
Yeah.
cause harm or to coerce or prevent future harm, but also to send a message to society that certain behaviors are frowned upon.
Look,
And partly, I think part of the mission of the language around the law, like the cliche about better if 10 guilty men go free, is to set a certain sense of what society is about. My question is, in your chapter about terrorism, for instance, is very clear about how, in truth, most Americans, and I think most humans, will agree that there are circumstances where torture is not only justified, is required in order to prevent imminent danger. But your argument, which is a very profound one, I think, is that we are doing this covertly and extra legally, and as a result, it exists in the black holes of the law. And
right.
what you're calling on is treating this in the same way that we do about issuing subpoenas or search warrants, where you will have a clear, transparent legal system that has standards by which the torture warrant is issued, and therefore including it perfectly in the law. My challenge is, if this happens, doesn't the acknowledgement that torture is part of the legal system also changes the view of the public of what living in a liberal democracy means?
Yes, absolutely. And it's a trade-off. It's a trade-off between overtly admitting that we're doing terrible things and doing them secretly. Look, we've been having this debate for 1,000 years. Most recently, it was between Kant and Bentham. Kant would say absolutely no torture under any circumstances. In fact, Dostoevsky deals with that in the Brothers Karamazov. What if you could improve the world tremendously so that nobody ever goes hungry again by just killing one innocent child? Would you do it? And the next question is, if you did it, would you do it openly or would you do it secretly? So Kant and Bentham argued that out. The Talmud debates that issue, and I'm in favor of complete transparency. If we're going to do it, I want to do it openly. I understand the cost of that. That means that we acknowledge that maybe under extreme circumstances, torture would be justified. And by the way, the vast majority of people in the world are not Kantians, they're Benthamites. And they would say that if you could save 1,000 innocent lives by torturing one guilty person, we should do it. In fact, Bentham came up with a brilliant, I quote it in the Preventive State, a brilliant hypothetical. He says, what if there's a gang of people who torture people and you capture the head of the gang? And by torturing him, you can stop the torturing of thousands of people. Would you allow the torturing of one guilty person to prevent the torturing of 1,000 innocent people? I mean, it's a very compelling hypothetical argument. And Kant doesn't deal with the issue that you profoundly raise, and that is, what does it do to a legal system if we acknowledge that torture is permissible? Maybe it's better just to do the torture, but deny that we did it. I'm a complete and categorical opponent of that. I think the essence of democracy is transparency. And so I'm always in favor of whatever we're doing, making it public. And in my book, The Preventive State, I make a very strong argument for transparency, which is why I think we need a jurisprudence of probabilities, which is something, most Americans don't like. Look, the difference between, for example, Catholicism and Judaism is very profound. In Judaism, in the Old Testament, we have the story of Abraham arguing with God over whether it would be ever proper to destroy all the people of Sodom. And God, admits if there are 50 innocent people, no, I won't do it. 40, 30, 20, and they stop at 10. The Catholic Church is very different. Their view is morality is absolute, and you can't, under any circumstances, violate the rules of morality, even if it means the entire universe has to be destroyed. So these are arguments that will never be resolved. My point is, let's have the arguments out in the open. That's why I wrote The Preventive State, so that we can debate this issue in the context of the preventive state, an issue that has been debated since the Bible was written back, 3,000 years, 3,000 years ago.
So just to be clear, you believe there is no place for intentional legal ambiguity, legal grayness, Straussian deception, no room for that in the law.
No, I wouldn't say that. I would say that I'm against it. But I'm not an absolutist. I'm a moral relativist. Let's be very clear. If you can persuade me that keeping secrets and not disclosing is better for society, okay. I haven't been.
You could be persuaded if there is a strong consequentialist argument that the moral social value of existing in a Benthamite legal system while believing you're in a Kantian one, that could persuade you.
That's a brilliant argument. I agree with you. And if we do that, we're compromising principles and values. But yeah, look, I'm in favor, for example, of temporarily not being transparent. I mean, we have to use deception. When President Trump sent his B-2s west instead of east, he was engaged in deception. There's a great story of when the president of Harvard, and I think it was President Eliot, may have been President Lowell, I'm not sure, one of the early presidents of Harvard, was told that Harvard had a championship baseball team. And so he called in the coach of the baseball team and said, how are you managing to win so many games? And he said, one of our pitchers has developed something called the curveball. And the president of Harvard said, curveball? In other words, you're deceiving the batter? You're making him think the ball is going to come straight and it's going to move away? That's not what Harvard men do. And he abolished the curveball, and Harvard started losing game after game. So, it all depends on context. Curveballs are permissible. Knuckleballs are permissible. Deception is permissible when you're sending B-2 bombers to destroy a nuclear facility. But deception is not permissible in many other areas of life. We put people in jail for fraud, for deceiving other people. So context is everything. And in the preventive state, I try very hard to distinguish among various factors when transparency is essential. Creating a jurisprudence does require transparency, but maybe the jurisprudence can include an area where transparency is not desirable. That should be part of the jurisprudence as well.
I want to give you a chance to give our audience your view about the source of rights, because the idea of individual rights is at core what's at risk.
Sure.
You have a very specific model of how you see rights originating.
Let me start by saying they don't come from God, because God doesn't speak with a singular voice, even if you believe in God. Uh, they don't come from any external source of morality. They come from experience, from human experience. Most of human history didn't have rights. You saw that Harvard discovered in its law library an original copy of the Magna Carta written in 1215. That may be the origin of some rights in Western democracy. So my theory is that rights come from wrongs, that human beings are uniquely capable of recognizing our mistakes. We don't always do it, but human rights grew out of the Holocaust. Civil rights grew out of slavery. Women's rights grew out of sexism. All of our rights were reactions to wrongs. And so I'm not somebody who believes in natural law or God-given law. I reject the concept in the Declaration of Independence, although the Declaration of Independence is itself ambiguous. In the beginning, it talks about the creator, and then it talks about human institutions implementing rights. I think rights come from a human recognition of wrongs, and there's nothing permanent about them, and they change over time. Even due process, the concept of due process, what does that mean? It means the process that's due to you, depending on who you are you a citizen? Are you a visa holder? Are you a green card holder? And what they're trying to do to you. Are they trying to execute you? Are they trying to put you in jail? Are they trying to deport you? Are they trying to deny you a visa? So it all is contextual. And so, yeah, I am a pragmatist. I am a relativist. I am a Benthamite, not a Kantian. Although if I could be persuaded that Kantianism will be better for humankind, my pragmatism and Benthamism would result in me becoming a Kantian. So for me, everything is consequential. And that's why I love the name of your program, because it recognizes the fallibility of the human mind. We're always going to be making mistakes. And in fact, if you ask me to summarize what is the law is how we deal with our mistakes. If we, as I think it was James Madison said, if men were angels, we wouldn't need a constitution, but we're not angels. And so we need laws to tell us how to deal with the inevitable mistakes that we're going to make. We're going to confine too many people sometimes. We're going to confine too few people sometimes. We're going to have too many false positives, too many false negatives. And that's why in the preventive state, I try to come up with a plausible beginning jurisprudence, hopefully that people can improve upon.
That's why historians and anthropologists often use legal codes as a way to look at the practices common in past societies, because the laws represent what that society was involved in. You don't have laws to prevent behavior that doesn't exist.
That's a mistake. Looking at formal laws is a mistake. If you looked at the laws of the Soviet Union under Stalin, and if you looked at the formal laws 1937 in Nazi Germany, you'd find the laws were, if somebody from outer space came and just read those laws, they would say, oh, these are two wonderful societies. So you have to look at the law in practice, in reality, rather than the law.
No, but I mean the things that are usually, when you can see a law saying thou shalt not, that's the thing that was being done. That was the thing that was being committed. It is I'm saying that as a tool of contrast. And even in Nazi Germany, you have laws outlawing and expropriating Jewish property. That indicates that Jews had a lot of property. They would not have had that law were it not for wealthy Jews. A country without wealthy Jews does not expropriate the property of Jews.
Yeah, and of course you can tell a lot by looking at the laws, but you can't tell everything.
Yeah, for sure.
You have to look beyond the written laws, the parchment preachments, as I call them, to the practicalities and realities. For example, take what happened after 9/11. one of the rules of my book, I create a law of my book. You can call it the Dershowitz Law. And that is when you have too many false negatives, when you underreact and fail to predict, like we failed to predict 9/11, we failed to predict October 7th, we failed to predict Pearl Harbor, then we tend to overreact and do too many things. We create the Patriot Act. We have a massive invasion of Gaza, whether you agree with it or not. We have the confinement of 110,000 Japanese Americans in camps. So the law is, Dershowitz's law is, if you make the mistake of under predicting, you're going to end up over predicting afterward, because we learn from experience. And what we often learn from experience is to overreact to our failures. And so that's why it's important to get it right and to prevent 9/11s and to prevent October 7th and to prevent other things that cause us to overreact. I was asked when I was like 23 years old, I was a law clerk on the Supreme Court, and I was asked to serve as an assistant on the Warren Commission to determine who killed John Kennedy. And my then boss, Arthur Goldberg, said, "Don't do that." I said, "Why not? It seems like a great job." He says, "Because the Warren Commission's conclusions have already been determined. The President of the United States has said, we must conclude that the Soviet Union had nothing to do with this, because otherwise there'll be World War III. So the Warren Commission had the authority to conclude anything they wanted, but not that the Soviet Union had anything to do with it. Now it turns out the Soviet Union didn't have anything to do with it, so the Warren Commission may very well have been accidentally right. But my boss told me not to get involved in a deeply flawed process where a result has already been determined. And
or at least the horizon of possible results has been constrained.
Yeah, has been constrained. And I think we often see that in life, that we refuse to accept certain conclusions because those conclusions would lead to catastrophe. So, to get back to the preventive state, all I'm calling for is a recognition that we're doing a lot more prevention than we have done in the past, and that we need to begin a discussion about how to cabin that extraordinary power that the government has to act in the name of prevention, because it seems so benign. If we say, "Oh my God, an ounce of prevention is worth a pound of cure," or "stitch in time cures mine, saves nine," it's so easy to give the government too much power in the name of prevention. And that's why I tried to create constraints on the government acting in the name of prevention.
Yeah, before it goes too far, I want to ask you about the possibility of AI reading into the probabilities, maybe even iterating on ideas like yours and developing a more complicated way to evaluate the probability of harm. I worry about that scenario for many reasons, but let's focus on one because it was a little redolent of your Dostoevsky example. I don't know if you read the short story "Those Who Walk Away from Omelas," but it has the same narrative where a town lives prosperously, thrives, and the only cost they pay is that one child is being tortured infinitely from the moment they're born until they die in a cave, and then that child needs to be replaced over the years. That is the one act that redeems the entire town. Now, what I worry about AI, because AI is so opaque to us, the logic of AI is so opaque, I can see a scenario where if you feed it enough information, it draws information from the magnificent capacity for surveillance that the modern state has, and it starts evaluating certain risks and certain human behaviors and certain patterns, that it starts giving us an output of preventive regimen that doesn't make sense to us, like, never cross the street on a Tuesday, or always turn off all the lights after 4 p.m. We don't understand the logic because we don't understand how AI thinks, but the result might actually work. We've stopped crossing the streets on Tuesdays, and suddenly crime has dropped 20%. We don't understand how this happens. AI has proven itself. It is a successful preventive measure, but there's something, and it doesn't have to be as grotesque as a child being tormented, right? It just needs to violate our causal understanding of why doing A results in B.
Well, we already have that. I take aspirin every single day to keep me alive at age 86. None of my doctors understand why aspirin does that, but they all tell me that the experiments show that if I take a baby aspirin every single day, it will extend my life and extend my health. So I do it without question. Now, I'm curious. I'd love to see research on that. But, these arguments go back in the Talmud. They tell the story, and it was probably a true story, of the Romans capturing a Jewish city, a walled Jewish city. And the Roman generals say to the Jewish mayor of the city, we're going to destroy the whole city and kill everybody, all the babies, all the children, all the mothers. We're going to kill everybody unless you send one person out, and we will torture and hang that person, and then we will leave the city alone. This is in the Talmud. And the rabbis give it's a great hypothetical, and the rabbis give an absurd answer. They say that if the Romans say send anybody out, you can't pick who's going to be sent out. But if the Romans say send out John Smith, you can send out John Smith because he's already been sentenced to death, essentially. It's an absurd response. And maybe it's a response that says, God picked John Smith. So it's a religious response. But the point is that going back 2,000 years, they've done this argument that Dostoevsky so brilliantly presented in The Brothers Karamazov, and that your author in his short story presented as well. I mean, life is often a choice between harming an innocent person and saving other people. Even the very concept of an inoculation. Let's assume there are two kinds of inoculations. There's an inoculation that doesn't help the spread of disease, but it helps you get better. That's one thing. The other one would be, hypothetically, one that doesn't help you get better, but it just helps the spread of disease, and indeed it poses a risk to you. And so we ask the question, would we require you to be inoculated, even though it raises the chances you'll die by 2%, in order to help other people not get sick? These are the kinds of trade-offs we have made from the beginning of time and will continue to make. And all I'm suggesting is, let's think about it. Let's have a jurisprudence, and let's understand and recognize that we are moving toward a preventive state, and we should be doing it without blinders on, and we should be doing it openly and democratically. And that's what I try to do. That's why The Preventive State is my most important book. I've written 57 books, and, like having 57 children, I love them all. But this is the one that, if I'm remembered in the 22nd and 23rd century, it will be because of The Preventive State, not because of all the other books that have been bestsellers. This is the one I'll be remembered for, even if it doesn't sell any copies.
Okay, I know we're running against time. Can I ask you one Talmudic question before you go?
Sure.
So you mentioned at the end of the book, you reference the Aven of Aknai, a Talmudic tale that ends with a rabbinical court dismissing an interpretation of the law that is more technically accurate, even though the court has reached a different interpretation. At the end of that story, God sends a heavenly voice to tell the court that, in fact, that rogue rabbi is correct. His interpretation is correct. And the court responds to God, it is not in the heavens. The law is no longer in the heavens. And God laughs and says, my children have defeated me. You see that as a story of usurpation and the consolidation of rabbinical power at the expense of the law. I just wanted to challenge you that I see that as the assertion of civil law and the final step in telling the divine that it no longer has a hold to arbitrarily inject itself into human affairs.
And I think you're right. I think you make a good point. We're having the same debate now with originalists in the Constitution. God is, the 90 people who drafted the Constitution. The rabbis are the justices of the Supreme Court, who are saying to the framers of the Constitution, you gave us a Constitution, you gave us a method for interpreting it. Now go back to your graves, leave us alone. We're going to do our job. Hope we'll do a good job, but if not, it's our responsibility. So, no, I agree with your interpretation. I don't like the heavenly voice, but I don't like the rabbis either. So see it more democratically spread out. And I don't like looking at the framers' intention, and I don't like looking at the 9 justices in the Supreme Court. I'd rather see many of these decisions made by the people in a democracy. You know, the Book of Ruth starts with a very interesting quote. It says, "In the days when judges ruled the land, there was famine." The message is that judges don't make good rulers. They're supposed to just decide cases and controversies. And judges have taken upon themselves far too much power, not only now, but in the 1930s and the 1940s. And we've seen that. And it's very important to strike in a democracy an appropriate balance between the 3 branches of government.
So I assume that you're against the ubiquitous justiciability of the Aaron Barak court in Israel.
Aaron Barak was one of my closest friends in the world. We met in 1966 when I was an assistant professor, and he came over as a visiting lecturer from Harvard. We are as close as human beings can be. I love him. He loves me. And I think he went too far. I think that he did a great deal of good. I would say 80% of what he did was positive, but 20% was not, eliminating standing and eliminating case and controversy. I think he gave too much authority to judges. Now, you know, if he were here, he would say, "You don't understand Israel. In Israel, you need to give authority to the judges because the legislatures are so corrupt." All I'm saying is that whatever impact Aaron Barak had in Israel, we shouldn't be borrowing it in the United States. It's not a perfect model for us. I believe in disempowering judges from being involved in what ought to be decisions made by the people.
You're against divine authority and philosopher kings.
That's right. Look, from the time I was 7 years old, my mother tells me I was fighting authority. I fought the rabbis. I fought the judges. I've been a confrontationalist. You know, I described myself in this book as a constitutional libertarian, a meritocratic egalitarian, and a constructive contrarian. And it's the last, I think, that I'm proudest of. I am a contrarian. I will always oppose authority. I don't believe there are absolute answers, and I believe in dialogue and process. And I wrote the Preventive State to start, not to end, a conversation.
And you're a Burkean, and at least in the way you define the rights, there's a very deep Burkean intuition about experience molding rights.
That was most influential in my law school career, perhaps, was Alexander Bickel at Yale Law School, and he was the personification of a Burkean. I really didn't know Burke's philosophy until I took his course, and I immediately identified with it. So I'm a Burkean. I'm a Hamiltonian. I am not a Jeffersonian. Am I a Democrat? I used to be a Democrat. I am no longer a Democrat. I am not a Republican. I am an independent. I should have been an independent all my life, but, you know, I voted for every Democratic candidate from John Kennedy when I was 21 years old to Joe Biden. So I am a Democrat by habit, but I'm worried about the Reagan phenomenon. I didn't leave the Democratic Party. They are in the process of leaving me. I'm going to vote for individual candidates based on their qualifications. I'm not going to vote party line.
Alan Dershowitz, thank you so much for the extra time, and I hope you have a wonderful day.
Well, you have asked me such brilliant questions. I hope we can circulate this tape widely because I think your questions are among the best I've been asked. I've been on a lot of interviews for this book, but this is about as good as any have been. And I want to thank you very much for your thoughtfulness. I know you read the book carefully and your questions have been superb. So thank you for giving me the opportunity to dialogue with you.
Thank you so much. It's been an honor.
Thank you.